Alrighty, party peoples of the interwebs, it's time for your daily dose of the Trump update in the New York. Alvin Bragg, Stormy Daniels, hush money, election interference, bullcrap, persecution, and don't worry, the totally unbiased, uncorrupt Judge Juan Marshall quashed Trump's subpoena. Duces tecum, I'll explain. Viva Frei, former Montreal litigator turned current Florida rumbler in my actual home office, as you can see from the neon light in the back. The daily dose of the Trump trial update. It's Wednesday, and from what I understand, they are sitting in this trial 4 days a week with Wednesdays off. And today, we are waiting on news from the judge as to whether or not he imposes sanctions for contempt of the gag order against Trump. We'll see where that goes. But the update news of the day, the judge quashed a subpoena, duces tecum, that the Trump team issued for Stormy Daniels to bring with her a slew of documents between her and a number of other potential witnesses. I'll get to it right now, but what is a subpoena, duces tecum, you might be asking?
You know I don't speak Spanish.
And if you're not asking that question, it's probably because you speak Latin. Subpoena, duces tecum means a subpoena, bring with you the documents. Let me double check that that's exactly what it translates to. Subpoena, duces tecum, pronounced in English, I don't know what the heck that is, or subpoena for production of evidence, is a court summons ordering the recipient to appear before the court and produce documents or other tangible evidence for use at a hearing or trial. Etymology: the phrase subpoena duces tecum is a Latin expression meaning literally, quote, under threat of penalty or punishment, you will bring it with you, end quote. So the Trump team issued this subpoena duces tecum on Stormy Daniels, and there was a contestation, a motion to quash the subpoena duces tecum for the reasons which we'll read in the order. The judge heard it, and because the judge has been siding with, who do you think? The prosecution, not Trump. The judge quashed this subpoena duces tecum. Let's see why. The people of the state of New York against Donald J. Trump. Defendant, decision and order on defendant's motion to compel compliance with subpoena duces tecum to Stephanie Clifford. And for those of you who might be confused right now, who the heck is Stephanie Clifford? Stephanie Clifford is the natural legal name of the porn star and confirmed liar Stormy Daniels, who is the star witness along with confirmed perjurer Michael Cohen in this case. Honorable Juan M. Marshall, AJSC. A little bit of the procedural posture. On April 4, 2023, Donald J. Trump, the defendant, was arraigned before this court on an indictment charging him with 34 counts of falsifying business records in the first degree in violation of Penal Law Section 1750.10. On March 18, 2024, defendant issued a subpoena duces tecum, hereinafter subpoena, to Stephanie Clifford, aka, quote, Stormy Daniels, end quote, hereinafter Daniels, seeking all materials related to the documentary film titled Stormy, hereinafter documentary. The subpoena also sought all documents for the period between April 2023 and the present relating to communications with, quote, Michael Cohen or his representatives Karen McDougal, Elizabeth Jean Carroll, Jessica Leeds, or Natasha Stroinoff, end quote. Finally, the subpoena sought all documents, quote, relating to communications with the U.S. Attorney's Office for the Southern District of New York, end quote, during the period of April 2018 to the present. Stormy Daniels' attorney filed a letter opposing the subpoena. Then defendants filed a letter or a motion indicating that they were going to compel compliance with the subpoena, which brought us before the court. And the judge says, I've heard both sides. I'm going to quash that subpoena. Duces tecum. Here's why. Discussion. For the following reasons, defendant's motion to compel is denied, and the people and Daniels' motion to quash are granted. Now, I'm not going to go over everything I've already said about how this bogus persecution was fabricated into a 34 felony charge indictment on what would be a misdemeanor under any circumstances. The totally not corrupt District of New York took what would have otherwise been, at worst, a misdemeanor bookkeeping error and turned it into a 34 charge felony indictment on the basis that there was some conspiracy to commit federal election law by mischaracterizing, by falsely stating that the payments to Michael Cohen were in fact not for legal services, but were intended to influence or interfere with an election by killing an unfavorable story, that being the allegations of a sexual relationship between a porn star and the president. Whether or not it was Trump who approached Stormy Daniels to buy her silence, or Stormy Daniels, a lying porn star who tried to extort Donald Trump, we'll probably get that evidence out in trial, but it won't be by way of this, because this motion to compel the production of documents has been quashed. Now, there is a little something of a silver lining that extends beyond the appellate rights as a result of having his request for evidence dismissed at this stage. Stormy Daniels will still testify because she is the star witness of the prosecution, so they will get to cross-examine Stormy Daniels, but at the very least for now, the request that Stormy Daniels bring with her a slew of documents requested in that subpoena has been quashed. Here's why, and I will steel man why this could potentially rationally be justified as a legitimate quashing of a subpoena. CPL, which stands for Criminal Procedure Law, Section 1610.20, provides that any party to a criminal proceeding may issue a subpoena. CPL Section 610.23 specifically provides that an attorney for a defendant in a criminal action may issue a subpoena of any witness whom the defendant is entitled to call in such action or proceeding. To, quote, sustain a subpoena, end quote, the issuing party must demonstrate, quote, that the testimony or evidence sought is reasonably likely to be relevant and material to the proceedings, and that the subpoena is not overbroad or unreasonably burdensome, end quote. Relevance of the documentation being sought and the subpoena cannot be overbroad or overburdensome, and you can see here how any motivated reasoning can allow anyone to arrive at the conclusion they want to arrive at. If you want to grant this subpoena, if you want to maintain this subpoena, you could say, okay, it's relevant and it's not unreasonably burdensome. If you want to quash the subpoena, you'll say the documents requested are not relevant or are unduly burdensome, overbroad. And which way does the totally unbiased and totally uncorrupt Judge Juan M. Marchand, whose daughter is profiting hand over fist as a result of this prosecution, which way does he want to go? He wants to quash, so he's going to find that the documents requested are irrelevant and the subpoena is overly broad and overly burdensome, and here's how he arrives at that foregone conclusion to which he already wanted to arrive. The Court of Appeals has held that a subpoena is properly quashed when the party issuing the subpoena fails, quote, to demonstrate any theory of relevancy or materiality, but instead merely desires the opportunity for an unrestrained foray into confidential records in the hope that the unearthing of some specified information will enable them to impeach witnesses, end quote. Unrestrained foray into otherwise confidential material in the hopes of finding something relevant to prosecute, persecute. Oh, you know, like exactly what they've been doing with Trump's counsel and Trump's inner team. Set that aside. We don't need to highlight the double standards, the hierarchy, the lawlessness of this persecution. Just understand those words. They need to show relevancy and materiality, and I can already steelman why they want the documents that they're asking for from Stormy Daniels as relates to the release of her documentary, whether or not she's getting paid for it, how much money she's getting paid for it, especially if extortion is going to be an issue here. Relevance and materiality is already painfully obvious. They want to see if she had any discussions with E. Jean Carroll as to how to extort money from Donald Trump. They want to see if there was any planning as relates to the release of that documentary called Stormy, I think it's called Stormy, with Netflix. Oh no, but they don't get to see any of that because, and I'm going to steelman it here for everyone out there, because all of these alleged acts, all of these documents occurred after the impugned acts, after the ledger entries in 2016, 2017. So they say all of this occurred after the fact. We're not limiting what we want to look for to anything that the judge considers to be relevant or material. My goodness, I can steelman both sides of this, but the bottom line, Stormy Daniels is still going to testify. They can still ask her these questions if it becomes relevant on cross-examination, but at the very least, for the time being, they're not going to get any of this information in advance. When deciding a motion to quash a subpoena, quote, access must be afforded to data relevant and material to the determination of guilt or innocence, as, for example, when a request for access is directed toward revealing specific, quote, biases, prejudices, or ulterior motives of the witnesses as they may relate directly to issues or personalities in the case at hand, end quote, or when it involves other information which, if known to the trier of fact, could very well affect the outcome of the trial. There is no such compulsion when requests to examine records are motivated by nothing more than impeachment of witnesses' general credibility, end quote. And you can see here how, based on the motivated reasoning theory, the judge can arrive at whatever conclusion he wants to. If he wants to maintain the subpoena, he could say, yeah, of course this goes to prejudices, biases, ulterior motives of the witnesses. And if he wants to quash the subpoena, he could say this is just a general foray into irrelevant stuff, relevant only to impeach the general credibility of the witnesses, hence quashed. And that's what the judge does, quite obviously. Defendant's first request seeks, quote, all documents that relate to the documentary and one or more of the following topics, end quote. Defendant's first request mirrors that of requests sent to NBC Universal on March 11, 2024 in a subpoena that was quashed by this court on April 5, 2024. And here you have the totally unbiased, totally not corrupt Judge Juan Marchand relying on his own prior judgment to say, you tried this before, I said no before, and I'm going to invoke my own precedent to say, I said no before, I'm going to say no now. First, defendant seeks all documents, quote, that relate to the documentary and one or more of the following topics. A, the premiere of the documentary. B, the release date of the documentary. C, editing of the documentary. D, promotion of the documentary. E, marketing of the documentary. And the list goes on. You can freeze frame and read it for yourself if you so choose. What do you want? This request is overbroad and seeks general discovery. Subpoena duces tecum quashed. Now, in fairness, and I'll steelman it, it is a pretty broad request for documents, request for information. They could, in theory, I guess, reissue the subpoena and be a little bit more limited so the judge can't rely on this reasoning to reject or quash a subpoena duces tecum another time, but I think the judge will find any reason to quash it if he wants to quash it. But as relates to the other requests, similar conclusion. Defendant's second request seeks, for the time period between April 2023 to the present, quote, all documents relating to communications with the following: Michael Cohen or his representatives, Karen McDougal, Elizabeth Jean Carroll, i.e. E. Jean Carroll, Jessica Leeds, or Natasha Stroinoff, end quote. This request is overbroad, seeks general discovery, and is not limited to the subject matter of the case. Defendant's third request seeks, for the time period between April 2018 to the present, quote, all documents relating to the communications with the U.S. Attorney's Office for the Southern District of New York, Daniels 3/18/24 subpoena. This request is overbroad, seeks general discovery, and is not limited to the subject matter of the case. For the foregoing reasons, defendant's motion to compel is denied, and the People and Daniels' motion to quash are granted. So ordered, April 23, 2024. The Honorable J. Merchant. Why does that stamp actually look like Merdman? That does not say Merchant. That totally says Merman. Merman! So that's the latest. I can sort of steelman understand why the judge came to that conclusion. It was a little broad in terms of time frame. It was a little broad in terms of object of documentation to be communicated. They could, in theory, issue a more limited subpoena to get really at the issues that they want. We'll see where it goes, but for the time being, the subpoena ducis tecum is quashed. The trial picks back up tomorrow with David Pecker going back on the stand. He's been testifying for portions of 2 days now. He's the CEO or executive at AMI, which owned National Enquirer, and the most devastating of bombshells that have been revealed as of now in this trial is that the National Enquirer was running favorable headlines for Donald Trump and negative headlines against Hillary Clinton. Holy crab apples. If that's going to be a federal crime going forward, everyone who runs for office is going to be guilty of a federal crime. And I don't even understand what the theory of the case is here. That the guy who owned National Enquirer was running favorable headlines for Donald Trump. Are they arguing that he made an in-kind contribution by way of favorable press coverage that he didn't declare? In which case, he should be on the stand, not Donald Trump. But it seems that AMI signed some form of agreement with the prosecution, so I guess they're off the hook. Except Pecker didn't want to be there, and he had to be called in by subpoena. But that's it. We'll see where this goes. Trial picks up tomorrow. I will be live streaming the immunity arguments before the Supreme Court. Also a Trump case. What immunity does a president benefit from? As a president, is it broad immunity for everything? Is it a broad immunity with a small caveat for purely personal actions? Or is it what the Democrats want? No one is above the law, and the president doesn't have any specific laws that apply to him, such that anybody and everybody can sue him and judicially harass him the second he is out of office. We will see what the Supreme Court does, but I will be live streaming the oral arguments. Should be fun. If you like what I do, you know what to do. Like, share, subscribe, hit the notification bell, drop a comment in the comment section below. Viva Frei on Rumble, the Viva Frei on Twitter, vivabarneslaw.locals.com for the best above average online community anywhere. $10 a month to join, $100 a year if you get the entire year. More important than anything, get out there, exercise, talk to friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out, peeps. Booyah! Merman!